First and foremost, thanks everybody for joining this webinar. We are truly going to be coast to coast on this. This is part of a webinar series that BV's made available. One of the things we noticed last year when we did the webinars is we've got such great feedback on trying to host this again. While some of these are presented at different conferences, what we really wanted to do is create access in a meaningful way to as much of the market as possible. Obviously, this wouldn't be possible if we didn't have panelists. So we welcome what I call the three musketeers of environmental law and introduce each one of them in a little bit later of a slide. And you just want to hit the next slide here for a sec.
Yeah, no problem.
So this is season 2 of sort of the PFAS webinar series. We will have 2 more after this, and we'll continue to host them. We may have one in the fall, but we'll for sure be back next year. I'm not seeing the screen change, Andrew.
It should.
Okay, maybe. Oh, you know what? It's just me. So yeah, we've got the next one on May 15th. The one after that on May 29th. So if you haven't registered, now is an awesome time to register. If you have feedback around this, please let us know. I'll share a link here in the chat. And if you are jumping on, please remember to either put your phone on mute if you're in a meeting somehow. So it just will be important. And then I'll turn it over to Andrew just for a bit of an intro.
Yeah, thanks, Josh. So I'm Andrew White. I look after our PFAS efforts in Canada for BV. And it's been a great year of improvements and expansion for us, where the team has really made some great strides in our capabilities, and that's just sort of led to we now have the largest capacity in the Canadian lab, and we've really seen a drastic improvement in our on-time results delivery. And so I can share with you that so far for this year, we did make a change where we moved to a standard turnaround time of 10 days. What we found on keeping track of on-time results, we're actually reporting in an average of 8.1 days of on-time data. And so the team has done really well in making sure that we're getting results in your hands quickly. You want to take this, Josh?
Yeah. And so, data is something that's really, really important to us. We are a laboratory. We view a lot of data, but what's really unique about what we feel our laboratory is, we've really delivered. And so, we provide customers reports on everything from our TAT to the sample volume we've done to how quickly we've responded to you. We believe the service is actually world class. There was a study that was done of over 500 million customers, and those response times for this particular customer are at the tippy top for it. So if you're interested in said report, please scan the QR code, fill it up, and send it over, and we'll be in touch. Secondarily is even if you have feedback around this, you could use this survey to give feedback to us. So it's an option, and again, our service is our promise. I did want to quickly introduce the 3 speakers. As I mentioned at the top, these are some of the 3 best professionals on the environmental side from a law perspective. But not only are they incredible lawyers, they're incredible people as well. So Anand, he sits here in Calgary. He is an Ottawa Senators fan. We won't hold that against him. Matt is out of Toronto, claims to be one of the best mountain bikers in the law space. And Jackie, she's the former president of the Women's Law Association. So yeah, just what an honor to have these 3 kind of share a little bit about where we are from a regulatory side. So 3 musketeers, you guys can take it away.
Well, thanks very much, Josh. I'm just going to share our presentation here. Give me a moment. And if someone can let me know if you're seeing that, okay?
Yep.
Perfect. Thumbs up. Great. So thanks very much, Josh, Andrew, and the BB team for having us back again this year to speak about some updates as they relate to PFAS regulation and litigation in Canada. As Josh mentioned, my name is Jackie Stevens. I'm a lawyer and partner at Wilms & Shire based out of Toronto. I'm here with Matt Gardner, also based out of Toronto, one of my fellow partners, and Anand Srivastava, based out of Calgary. So we are going to give you that update. Just a reminder, our
Jackie?
present, yes.
Sorry, I think your screen might have, I don't see it shared anymore. I don't know if it's just me or not.
Unshared.
It was on, but now it's not. Yeah, folks are saying
Is
that.
it back
online.
on now?
Yep,
It's
it's
back
back
on
on
now.
now. Yeah.
Okay, sorry about that. So as a reminder, our presentation and the discussion that will follow is not legal advice. We have to give those sorts of disclaimers. We do hope that it's information that is helpful to you and your practices. And at the end of our slide presentation, we will have a AFFF fireside chat for you to engage with us, as well as some questions that I know Josh and Andrew have prepared. If you do have a particular situation or a detailed situation, we encourage you to reach out to us directly or to your environmental legal counsel to have that discussion. It's really hard to have those sorts of discussions over Teams when there are 300 plus people on the line. So let's get started. We'll first look at a little bit of background about PFAS, and I know you got some of that in the last session that BB put on. We'll look at the current regulatory regime as it sits in Canada, and then we'll look at some civil and regulatory litigation cases that have come up in the last 12 to 16, 18 months. And then we'll conclude with a couple of key takeaways, and then we'll transition into our discussion. So I guess I don't need to say next slide because I'm the one controlling the slides. There we go. PFAS is the term for a group of several thousand human-made and synthetic chemicals, including some common examples you may have heard of, such as PFAS, which is perfluorooctane sulfonate, and PFOA, which is perfluorocetonic acid. I got that one wrong. Sorry about that. Both of which are surfactants. PFAS are commonly referred to as the forever chemicals, and this is because they are highly stable and they break down at a very slow rate in the environment. In terms of our health, forever chemicals are extremely persistent. They are bioaccumulative, meaning they continually accumulate in the body, and they're toxic. And unfortunately, PFAS are likely already in all of our bodies. Consequently, these growing concerns about PFAS have spurred several legislative changes and some litigation. We certainly have heard about a lot of litigation in the US, but now we have a few key cases that are working their way through the system in Canada too. Everyone on this webinar has likely encountered PFAS in one way or another. These chemicals were developed in part for their stain resistance and ability to repel water, such as waterproofing fabric like Gore-Tex. PFAS are also commonly used as repellents in cosmetic products, adhesives, electronics, and firefighting foams, known as AFFF, aqueous firefighting foams. These firefighting foam, the use is important. It's important to note also because many legal matters that are currently related to PFAS contamination were identified at firefighting training stations and airports, where there still is a significant use of PFAS. This is just a graphic from CBC Radio 1. It looks at some hotspots across Canada, and you can see in southern Ontario, there are several spots, but there are many located from east to west and a few in the north, right at the very tippy top of Canada. So they are all across the country. Lots of these locations are airports and military training facilities where that firefighting foam is often used. This second diagram depicts a summary of 5 PFAS in surface water over a 4-year period between 2015 to 2019. And while groundwater is perhaps most susceptible to PFAS contamination, surface water may also experience impacts. So with that, we'll turn it over to Matt to talk a bit about the regulatory regime in Canada.
Thanks, Jackie. So we'll start with PFOS and PFOA, which are the most common PFAS compounds that we have. And they have been included recently on the federal toxic substances list under CEPA, the Canadian Environmental Protection Act. And CEPA allows the Minister of the Environment federally to post a notice to require any person to create a pollution prevention plan under Section 56 of the Act, or an environmental emergency plan, sometimes we call them E2 plans, under Section 199 of the Act for any substance on that toxic substances list. So adding these compounds onto the toxic substances list brings in and invokes CEPA to apply to those particular really common PFAS compounds. So that's a big change that we've seen only recently. The minister may also, under Section 54 of the Act, under CEPA, issue environmental quality guidelines, issue objectives, even issue codes of practice to prevent pollution of the environment relating to anything on the toxic substances list, in this case, the 2 PFAS compounds. So that's a big change. The next big change that we've seen recently, again, under CEPA, is a duty to report. And it's administrative in nature, but it's very serious, and potentially the penalties can be significant. What happened was, back in summer of 2024, both Environment and Climate Change Canada and Health Canada, 2 federal agencies that have jurisdiction over CEPA related aspects, and PFAS in particular now, they jointly published an updated draft state of PFAS report. And the draft report sets out a qualitative assessment of the fate, sources, occurrence, and potential impacts of PFAS compounds on the environment and on human health. All of that with the objective of informing decision-making, mostly obviously federal government decision-making about PFAS, but often the federal government will take the lead and then provinces follow. So this could be a big step in PFAS regulation in Canada. And the draft report concludes that the defined class of PFAS may have an immediate long-term effect on the environment or its biological diversity, or may constitute a danger in Canada to human life or health. Those are all kind of trigger buzzwords that relate to the Constitution and environmental protection, and allow for the government to do what it's doing to really start to put some teeth into regulation of PFAS compounds in Canada federally. Also in July of 2024, ECCC, Environment and Climate Change Canada, published a notice in the Canada Gazette about PFAS pursuant to Section 71 of CEPA, which legally requires both importers of PFAS compounds or PFAS-containing products into Canada, and also manufacturers of PFAS or PFAS-containing products in Canada, to report their 2023 quantities in a new portal that's online through the Government of Canada. And the purpose of doing so was to require these PFAS reporting importers and manufacturers to collect information. So the government wants information to better understand the nature and extent of how much of PFAS and PFAS-containing products are being imported into Canada, how much are being manufactured and used in Canada, with the goal of better refining and understanding how to regulate PFAS federally, at least in the near future. What's interesting is, although this came out of, there was the draft report, and then there's this fact-finding, data-finding exercise by the government pursuant to CEPA, for those purposes, there are legal ramifications. There is serious potential enforcement in terms of penalties if you fail to meet the requirements. So if you're an importer or you're a manufacturer and you don't fall under one of the many exceptions, there are exceptions for this reporting, you have to report. And if you failed to meet the deadline, which just passed in January, it was January 29th of this year, 2025, you could be charged, you could be facing penalties, fines in this case of up to 500,000 for the first offense and 1 million for subsequent offenses. So it's serious. There are serious penalties involved, and there are pretty stringent limits in terms of what might be required in terms of reporting. So the notice applies broadly to any person who manufactures, imports, uses any of 312 PFAS compounds listed in Schedule 1 with reporting quantity thresholds, subject to a number of exceptions, which we don't need to get into today. But the reporting thresholds otherwise are pretty stringent. So manufacturing of more than 1,000 grams of PFAS related material, importing more than 10 grams of certain PFAS material is set out in Schedule 1. There are different quantities for different purposes that we're not going to get into detail about, but there's also a total quantity greater than 10 grams of any PFAS compound, whether the substance was alone or at a concentration at or above 1 part per million in a mixture or in a product. So just generally speaking, those are some of the limits that we're bringing to your attention for different products and different purposes under the statute. So the next slide we have here is the generic pollution prohibitions concept that at least the Three Musketeers, so to speak, in our firm and others have been speaking about for years, because PFAS, even before it really started to become truly regulated federally or provincially or even municipally in Canada, always was in the background, technically speaking, subject to our more generic pollution prohibitions. So that's nothing new, but we're just highlighting it again this year for all of you to remember that this is an important piece to the regulatory puzzle in Canada. So we have federal, we have provincial, we have municipal bylaws in Canada that set out these prohibitions. We've named a few on the slide. They all apply to discharging of contaminants, releases of contaminants, pollutants, and so on. Slightly different wording with each, but they generally prescribe prohibitions on pollution and also reporting obligations where you do pollute as soon as possible. And the first example is federal. It's the Fisheries Act. It obviously applies to discharges into waters containing fish or fish habitat. And there are reporting obligations under the Fisheries Act where you do discharge or release a deleterious substance. And PFAS compounds can constitute deleterious substances under the Fisheries Act. Similarly, just using one province, Ontario, it's an easy one. For example, we have our two primary statutes. The Ontario Water Resources Act, which applies to discharges of materials or substances that impair or may impair the quality of water, to water bodies. And then we have the more general Environmental Protection Act in Ontario, which prohibits discharges of contaminants that may cause an adverse effect or could or do cause an adverse effect when discharged into the natural environment. So usually land, but also potentially water. We also have, last but not least, municipal bylaws across the country that prohibit certain discharges, and they place reporting obligations when you do discharge of contaminants into sewers, storm sewers, combined sewers, sanitary sewers. And there is the possibility that PFAS-related contaminants in that discharge to sewers could be caught within the bylaw, depending on what the language of the bylaw is. So next, we're talking about drinking water federally with guidance now that we have guidelines from Health Canada federally that layers on top of everything we've talked about already that's federal. But this is guidelines for drinking water specifically under our Canadian Drinking Water Quality Guidelines, which are created and revamped and updated all the time based on scientific research relating to health effects in particular, but also aesthetics, taste and odor, and certain operational considerations as well for wastewater and water treatment plants and so on. And the guidelines for the for Canadian drinking water now establish maximum acceptable concentrations for a number of chemical parameters, physical parameters, including PFOS at 0.006 milligrams per liter, PFOA at 0.0002 milligrams per liter, and then the sum of PFAS and PFOA concentrations divided by their respective maximum acceptable concentrations should not exceed 1. So these are guidelines. They apply to drinking water federally across the country. And they are definitely guidance that's informing drinking water standards. For example, the interim standards that we have in Ontario now, which are guidance, not law, but it's the start of getting into drinking water regulation relating to PFAS compounds in Canada. And in addition, there are informal screening values for an additional 9 other PFAS compounds, those that are expected to be less toxic than PFOS and PFOA, but those have come out as well. Again, guidance, but this is paving the way for potential regulation, further regulation, federally and maybe even provincially from there across the country. So speaking of provincial, here is just a slide of examples of legal standards that apply in the context of contaminated sites primarily, and drinking water and surface water within the contaminated sites regime. These are examples where we do have now legal standards for certain purposes in 3 provinces, just as an example here on the slide, BC, Alberta, and Nova Scotia. And these are implemented and are, again, legal standards that do apply and regulate in the contaminated site space, for example. BC regulates PFAS under its contaminated sites regulation. Alberta's updated its Tier 1 and also Tier 2 soil remediation guidelines, which are standards, despite the name guidelines, to include some PFAS compounds and limits. And Nova Scotia, for example, on the East Coast has implemented PFAS standards relating to their environmental quality standards and pathway-specific standards, exposure standards, basically, in that province. So I'm going to turn it over to Anand now to take us through probably the most exciting part of the presentation, which is what do we have in terms of enforcement and litigation in Canada, and not getting into the previous cases that we've talked about last year and in other presentations, but what's new. Anand.
Yeah, thanks, Matt and Jackie, and of course the BV team. You guys are so kind, right? You've left me with what I would say is the fun, but those involved in the litigation would of course disagree with me. So just taking a step back, Jackie and Matt have teed up, the topic and the compliance angle, and now we pivot to the enforcement angle, and that enforcement can be either done privately, and we typically call that civil litigation. Those are, we would commonly call lawsuits, right? Actions, class actions, where parties, individuals, corporations, indigenous nations have disputes with one another. And we'll start there, and then we'll move to regulatory liability and litigation. And that's all about what the government can make you do, stop you from doing, or punish or penalize you for already having done. And so let's start on the civil side, and then we'll work our way to the regulatory side. And as Matt mentioned, we're slower in Canada than south of the 49th parallel, at least for most of our country, as to where and how fast the litigation is progressing. But there are important updates over the last year, and we're expecting that really to continue to rise on a, I would say, almost exponential pathway. And so what we focus on today is what's new. You may have heard us last year talk about, I think, what was an initial breakthrough in PFAS litigation in Canada, which we won't get into in detail today, but there was administrative litigation, typically occupational health and exposure. There's a board called the Veterans Appeal Board, which hears cases and had heard different health exposure cases, often involving firefighters and PFAS exposure. And unfortunately, those individuals had developed different cancers, which that board was willing to attribute and draw that causal link between the occupational exposure to PFAS and the outcome and the certain remedies and benefits that those individuals were entitled to. So that maybe was last year's update. This year, we get really into the class action context on the civil side. And so on the screen, you'll see there's a reference to a class action that's been started. But interestingly, it's started by the province of British Columbia on behalf of the other provinces and territories. So often when you might hear a class action, you might hear individuals, a group of individuals. They may be specified by where they live or where they work or what they may have done. So there's some commonality to the class. Here we have a provincial government taking aim at a number of manufacturers and seeking compensation for harms to its population. And BC's done this in the past with tobacco and opiate manufacturers, so it's not unheard of. But here we see BC venturing into the environmental realm as the representative class plaintiff. And so this proceeding is against a number of manufacturers of PFAS and PFAS-containing products. There's some distributors listed as well, and it is all about impacts to drinking water systems. And so the allegations are about negligent design of defective products, negligence in failing to warn of risks, breach of the Federal Competition Act, civil conspiracy. It's a complex and interesting piece of litigation. And again, it's just getting off the ground. It was filed last year. Jackie, if you wouldn't mind going over to the next slide, here's another example. And for better or worse, and you'll see it on the last slide, you see it on this slide, the defendants in these class actions are often listed alphabetically. And while 3M Company gets tagged in the short title of all of these. But in reference to the first one, there's a plaintiff, and this is in Quebec. The plaintiff's alleging that various defendants' products, including 3M and others, have contaminated drinking water sources in Quebec, endangered public health and the environment. And again, a similar type of allegation with, seeking compensation for the defendants allegedly knowingly developing and marketing these substances for decades while concealing the known health and environmental risks. And you can, that theme I mentioned earlier, tobacco, opiates, it's been seen and established in other types of class action litigation and very prevalent now. And there's a few more listed on the slide. Different representative plaintiffs. There's a couple of individuals in Ontario and BC listed. There's an Indigenous nation listed in Manitoba as a representative plaintiff. So you see that it is coming from many different angles. Jackie, if we flip to the next slide, there's one more example which is interesting, and this is out of Newfoundland and Labrador. And as opposed to going directly after industry, or perhaps solely going after industry, this is a class action against the federal government, and specifically Transport Canada, on behalf of a group of owners and residents in a subdivision in Torbay in Newfoundland and Labrador. And here we have a little bit more of the localized impact. The action relates to PFAS contaminated groundwater that's allegedly impacting the well water of the residents of this neighborhood development. The allegation is that the impacts are caused by the use of AFFF as part of firefighting training at the St. John's International Airport. And the history here is that Transport Canada has previously taken steps to remediate the airport, or at least portions thereof. And the allegation is that those steps were failed to be timely, complete, or effective, failed to contain the release, failure to employ proper remedial measures to prevent both the initial contamination as well as the continued migration. And the damages that are sought are for nuisance, which is the interference and enjoyment of land, diminution in value, stigma, costs associated with investigation, remediation, monitoring. And so this is an example of, I'm not trying to comment on importance, but one of a more localized nature of a particular subdivision, which again, the representative class is impacted by one alleged plume as compared to the other examples, which were more national in nature, driving at the broader concerns of health and the environment. So Jackie, if we could switch over, so let's flip from the civil side to the regulatory side. And remember, we talked about regulatory liability and litigation typically being what the government can make you do, stop you from doing, or punish you for having done. And as Matt referenced earlier, When I say government, there are different levels of government, all with differing overlapping areas of jurisdiction, the federal government, provincial governments, and at times municipal governments. And so just picking an example, Group Marcel is a Canadian manufacturer of branded products in the beauty industry, makeups, cosmetics. They're based in Quebec, and they were issued an order by the federal government, Environment and Climate Change Canada, in 2023 about marketing products that contained PFAS. And here we go a little bit further into coming up to present day. And again, Group Marcel found itself under scrutiny when ECCC officers conducted audits and inspections and identified marketing of cosmetic products. In this case, it was eye and lip pencils. And the concern was that they contained a particular compound, perfluoroanyl dimethicone. And so Group Marcel was charged. Now, so this is a prosecution after a previous order, which we probably talked about last year, and subsequently convicted in this prosecution under Section 81, sub 4 of CEPA for failing to provide the required regulatory information about the marketing of this compound, perfluoroanyl dimethicone, as that being a new activity that may pose a risk to the environment. And you'll see on the slide there that they were ordered to pay a fine of $500,000, $500,000, and those products have since been withdrawn from the distribution chain. So this kind of ties back to what Matt was speaking about earlier with more recent regulatory advances in Environment and Climate Change Canada and the federal government generally seeking information about PFAS and a failure to report, a failure to be accurate, you'll see it comes with significant potential penalty. I'll stop there, and Jackie, toss it back to you.
Thanks, Anand. So just to wrap up, there have been some even more recent developments in the PFAS space, and those include in March 5th of this year, the Government of Canada announced that the class of PFAS, excluding fluoropolymers, is harmful to human health and the environment. They made that conclusion, that statement. And the government is proposing to add the class of PFAS to Part 2 of Schedule 1 of CEPA. And in doing so, they're planning on doing this in a phased approach. Phase 1, beginning in 2025, will address PFAS in firefighting foams that are necessary for the protection of people and the environment. And sometimes we know that AFFF and PFAS firefighting foams are very effective for what they were designed to do. So some of the issue, and we see this in phase 2, is about looking at limiting exposure to products that aren't necessary to protect human health or safety or the environment, such as cosmetics or food packaging, but may not necessarily have a replacement. And there's some additional ongoing review that is happening there. And so phase 1 is firefighting foams, phase 2 is other products. And the federal government will require reporting of those manufacturing and other facilities of the use of PFAS to the National Pollutant Release Inventory. All of this is open for public comment on the risk management approach that the federal government has created, as well as the proposed order to add the class of PFAS, and that is open until May 7 of 2025. So it's still, I guess, a little up in the air whether we'll see this go through, but I suspect it probably will be the case. So just to pull this all together, I think we can make a few conclusions about what to expect next. I think we definitely are seeing PFAS as a growing area of concern from many different perspectives, health, safety, the environment. So one of the considerations is how business practices can avoid the release of PFAS into perhaps the waste stream. So we need to look at the areas where PFAS is where PFAS are and where that concern is growing, and how we can manage that on a go-forward basis. We've seen an increase in litigation. Anand spoke about 5 class actions in the latter part of 2024 getting started. Those have not been proven in court, and they're just at the very beginning stages. But that's more than we've seen in, I don't know, when was Egan, Matt? 2017 or 2020? Like, there's one other case that's been going through the system for a while. But this is really the most we've seen happening in recent times. And as we learn more about and understand better PFAS, I expect we'll also see more civil claims being advanced than we have seen in 2024. And Anand made a great distinction between the ones that are about drinking water systems in an area or a province versus the Newfoundland example, which was specific to a particular development. The first bunch were against the manufacturers of the product or the distributors. The second, that Newfoundland case, was against the Transport Canada, who was an entity that used a PFAS product. And then we saw regulatory enforcement being stepped up from not just an order to Groupe Marcel to an actual prosecution. And I think we'll see more enforcement in that area in the future also. So just before we hit the discussion, we are a firm of 14 lawyers. We've been practicing in the environmental space for nearly 50 years, and our lawyers are equipped with a broad set of experiences and skills, and we practice across the country to support our clients with their legal needs. So perhaps I'll stop sharing I'll flip one more. Here's our contact information. You can also go on our website and find each of us and our other colleagues. So perhaps Andrew and Josh, I'll stop sharing and back over to you.
Yeah, no, that's awesome. And yeah, thanks for that overview and the 3 kind of unique perspectives. And there's so many ways we can take this, but maybe we'll start with, with Canada signaling that PFAS will be added to the National Pollutants Release. What do you see as the legal implications of this, given that this will be publicly accessible data?
I can start. Okay. So yeah, the MPRI, right? So this is like what we say, for example, in our excess soil presentations and to clients in Ontario, where there's any form of a registry. So this is an inventory, the MPRI, and it's publicly accessible. So it is what I always like to use in terms of a phrase to just help clients understand why it's important, is it's notice to the world. So if it's public, and although it's not as though, the general person in the public knows what it is, knows how to access it, knows how to search, it's still nonetheless a public database or inventory federally for certain compounds. And with that PFAS future link, it becomes notice to the world about certain uses, where it goes, how it's being distributed, what's going on with PFAS at certain sites, and so on. And any notice to the world can then give rise to further inquiries. If it's a FIPA request or an FOI request or an ATIP request federally, that can cause the public or those who are involved in deals or those who are involved in litigation to make further inquiries, figure out more about where there may be PFAS related, fill in the blank, usage, spillage, what have you. And then that can give rise to, lo and behold, some form of litigation or enforcement. So I think that's the main tie-in, is that's just one of those additional layers of an inventory, a public database where information can be sought and obtained, or at least the start of inquiries for information to be sought and obtained by the public in particular.
If I can add just one more thing, and Matt, I totally agree. it's a live question. I think probably folks on this call will have very interesting perspectives. But does a phase 1 environmental site assessment for those who practice in that sphere, the consultants on the call, consider PFAS impacts or not? And I leave that as an open question. In the past, there may not. I mean, there are some obvious users and sources which we've talked about today, but as you get into creating registries and information, you think about what you may see otherwise in a phase 1 environmental site assessment and the different environmental reporting and searching services that are available, pulling in different, whether it's waste manifests, hazardous waste reporting, public registrations, things like that. You can see PFAS now being wrapped into all of that, and that starts to take you a little bit out of, so far a lot of what we talked about was the manufacture and produce and distribute world, and that is, and those industries of course are at the leading edge of this. But really, as it becomes incorporated into those types of environmental reports, you start to push into real estate transactions and banking and lending and insurance considerations that really have a huge knock-on effect on all of this, just as a lot of the other contaminants of concern that we deal with do. So I expect to see, Josh, just to tie back to your question, right, like a lot more sophistication growing in a lot of related industries as we get more and more public information about users and amounts and types of these types of compounds.
Yeah, no, that's well said. Jackie, do you want to add anything, or do you think you're...
Whoops, I'm good on that one. They covered it.
Yeah, so Andrew, I know I said next, but Anand, you just touched on something around the quote unquote users. Do you want to just walk through Brittany's question here, which is what constitutes a person, an entity to be a user of PFAS? I just want to talk about that a little bit.
Yeah, for sure. There's, we live in such a global supply chain, right? And I appreciate that there's a lot of disruption to that today. But where does PFAS and these types of compounds get introduced into the supply chain? And so you think about, if I may make a product, then there may be a packaging element to that product, and there may be a distribution element, which hopefully doesn't pose a significant risk, and then there may be a use of that product, and whether that use changes or has the potential to kind of knock free certain contaminants of concern. And so when I say user, I'm probably not referring to the end user, my phone and my mouse, and I'm concerned what's in all of it, but I don't know. But as you work your way back up the supply chain, I'll give you an example. I had a client consult me on this exact issue, where as navigating the PFAS reporting requirements, they were unclear. They are not the end retail seller of this product, but they are the ones who import the product and distribute the product. And so are they to report on behalf of everybody? The issue is the packaging in this instance. And so you can imagine in that supply chain, I would say all of those are quote unquote users, whether they're manufacturers or not. And each of them has an obligation now, especially as the obligations from a regulatory perspective are changing, to really make inquiry as to what are we doing, what are our inputs, what are our outputs, and what obligations do we have to report or not.
Yeah, no, that's awesome. Andrew?
Yeah, it kind of ties in with another question in the chat, is what sort of happens to the passive receivers, whether that be excess soils are receiving something, or a waste treatment plant or a landfill that now they have this problem that they didn't create, but it could be potentially huge for a landfill or a treatment plant.
Anand, do you want to
Yeah,
jump on that
I'm
one? I think maybe
I'm
you
happy
have
to. Yeah.
some personal experience, like client, obviously not sharing client information, but
Yeah.
client experience.
Yeah. Well, look, for sure, Andrew, and appreciate the question in the chat. It's very difficult, right? The nature of these chemicals and their persistence means that they are being moved from point A to point B, and so we come at it from different perspectives. I think the first perspective is there's a lot of scrutiny on municipal infrastructure now, um, even though the municipality is not likely to be the source of the impact itself, or the creator, manufacturer, distributor, we'll say. And so I've got experience working currently with, how are municipalities going to seek to regulate, and what information are they going to seek about what's coming into their systems. And then similarly, you're going to see and continue to see federal and provincial governments regulating down on municipalities in terms of what is it that your systems can and cannot do, what treatments are expected, what is the quality of your wastewater, drinking water. And I'm working on a site right now that has all of those at play. And if you kind of look south of the border in the States, there are, in addition to some of the types of litigation we've talked about today, a lot of litigation surrounding municipal drinking water infrastructure and who is responsible for those costs. Because that arguably is the most direct exposure. If you look at drinking water to our population en masse, and I've had the benefit through my work looking at some of the studies about low-level PFAS concentrations in drinking water, in wastewater, in the natural environment. That one could argue that might be the most common exposure that the general population has, and so you can see why that's a direct point of regulation and concern. And then if you kind of flow that through to excess soil, to landfills, to other movement of material. I mean, landfills is another good example. You see a lot of landfills now seeking information, understanding the leachability of certain parameters or not, and how that may impact both whether they accept and how they're going to price the acceptance of these types of materials. So really good question. And I think I've probably raised more unknowns than answered, but Matt, what do you think?
Well, I'll just add in, I mean, the question also just said, landfills as an example. So I completely agree with everything you're saying on it. And then the additional piece to this is where we don't yet have standards in certain jurisdictions for certain purposes explicitly for, that, whatever it is, whatever that use is. So in the case of landfills that need approval, so in Ontario, they need an environmental compliance approval, or we have new landfill lights. They're not really landfills, they're transfer stations essentially under the excess soil regime. So they're class 1 soil management sites, which take soil, are allowed to do things under their approval with the soil, and then have to have that soil removed and go elsewhere after a certain amount of time. But there's processing and storage going on, and those soils very likely could, in certain circumstances, have PFAS contamination in them. Right now, we don't have excess soil quality. I'm just giving an example. Don't have excess soil quality standards specific to any PFAS compounds. Is it coming? Will it change? Potentially it could, just like we've got with BC and Alberta with site condition standards. And in Ontario, we may have site condition standards and at the same time, excess soil quality standards that apply to certain PFAS related compounds. That could happen. Presumably it will happen at some point. That's a big driver at that point, because a lot of the ECAs, for example, like these approvals for landfills or transfer stations, speak to contamination above standards. For example, what table of and quality of material are you allowed to take or not allowed to take? Currently, expressly within those ECAs in certain circumstances, PFAS is not included. So it just depends on the jurisdiction. In Alberta, it could be very different with a contaminated site than it is here in Ontario, for example. But there's that piece to it. And then there's just general objectives as well. And I think, maybe we can talk about that under a different sort of question or whatever, but it all depends on what standards are there that apply to that specific situation, or what you think the standards may be doing in the future. What's your objective? What side of the coin on a transaction are you on? Are you buying? Are you selling? Are you a landfill taking material? Are you a hauler, transporting material? That's all. It's just scenario specific. And so that's the kind of like legal analysis that we have to do. Anand and Jackie are doing it with certain clients. I have a chrome plating client where we had to determine whether it was possible that they had ever used any sort of surfactant or material that would have contained PFAS compounds. The answer is no. But that's the kind of analysis that we have to do on a case-by-case basis currently. And it's always changing, so it keeps us on our toes.
Oh, that's awesome. So I think we probably have time for 2 more questions. Where I want to end is on Mark's question about safe alternatives, but we'll get to that one in a minute. But, considering the world that we live in is way more international than it's ever been. International influences have a ton of influences here in Canada. So given the international focus of PFAS regulations, including the US and Europe, how might these international developments influence kind of the legal landscape and potential for litigation related to PFAS here in Canada?
Yeah, for sure. Well, look, I'm happy to offer a couple thoughts, and then maybe Jackie and Matt chime in. I mean, I don't think it's a secret, right? Canada's not at the leading edge of, PFAS science development, standards development, maybe not technology development. I'm not suggesting we're lagging. I was on a panel last month with a practitioner who did a lot of work internationally, and his view was that Australia was out in front only because that they were forced to deal with this issue sooner than other parts of the world. And then there was kind of we'll say a US European band, and then there was the Canadian band. And that was still a great spot for our country to be in, but maybe not right at the front edge. So I say that because I think there are a lot of lessons learned both on the standards development regulatory side and on the treatment side, which Canada follows. I think we see that. We mentioned the litigation lags a little bit behind. So some of the, we'll say, novel or innovative items might not come from our country. And you see a lot of, and there's a live question about what, the state of funding with the US EPA and what that does to regulatory advances or not in Canada, because you often see the tie to what the US EPA is doing south of the border, and whether that may be a laboratory technique, and you guys will know way more about that than us, or more of a litigation management in terms of how they regulate. So I'll stop there. I think, Jackie, Matt, that's kind of a high level. What do you guys think from your perspectives?
I was going to answer a different question because so Matt, you go ahead, and then okay. I want to inject with a different thought.
I'll be quick. I think also to add to that, Canada is less litigious in general, obviously, stating the most obvious thing today, than the US, and we just have fewer lawsuits, and also we trend and follow, especially in class action space, for example, depending on whatever the subject matter is, and PFAS is a great example. We see what's going on in other jurisdictions, particularly the US, and then that can give rise to more civil litigation, for example, in Canada. Regulatory orders, prosecutions come with only if you have the teeth in your statute or regulation to give rise to those regulatory enforcement mechanisms. But civil litigation, you're already seeing it. Anand took us through just from last year and into this year, where we're at with all of these new class actions that are all somewhat related, just because there's certain defendants who are the same defendants in the class actions. And that's just this big sort of growth area that we've seen in the last number of years, and it just keeps growing. So, and that's because, in part, we're seeing it in the US, and because the US regulates and starts the regulation process, generally speaking, and we're following to a certain extent, and we're being careful with the science and what we should regulate, not, and which jurisdiction and for what purpose. All of that drives litigation. Will we ever have the same scope of litigation and breadth in Canada as we do in the US? Never. But the trend is there that it's increasing. We're seeing that now. So
I'm going to just jump a little differently and talk about a file that I've had where we're seeing in this particular jurisdiction, there are no standards or regulations that require looking at PFAS. But there are elements where, as an environmental professional, you look at a site, and Matt mentioned a chrome plating client, you look at a site and you have to assess if PFAS is something that might have been used in the history. Even if you don't have to sample for it, maybe you're going to do so because of that. And one of our files, because a property had been used in the past for adhesives manufacturing that could have a PFAS component, there was a potential for, and as we were going through the record of site condition process, the concept of new science came up, and whether the ministry was going to require us to do sampling as it relates to PFAS because of a former use of the property, where there are no regulations or guidelines or standards in Ontario, in particular in relation to that redevelopment aspect, that we would have to do anything. So we are seeing, PFAS emerging in different areas that, even though the regulations don't specifically say you have to do something, unlike Alberta, Tier 1, Tier 2 guidelines now have standards. In Ontario, we don't. So it is a bit of the driving of, as you find out more information, as we hear about what's going on elsewhere, and both internationally, the US and here, we're going to see those additional changes. But always looking at it, in particular as consultants, you're assessing a site for what it was previously used for. And I'm going to circle right back to contaminants include PFAS. So if you have a contaminated site, and we go back to the basics of pollution prohibitions, which is what most environmental protection statutes are based on, whether you have standards or guidelines or not, it is something that clients need to be thinking about if their particular site or facility may have used PFAS in the past.
So for a layman in legal terms, like myself, Jackie, could that have, so say you've done a phase 1 or a phase 2 or an RSC at a site, you did not look for PFAS, but then now you found, well, there was a historical spill or a fire and they used AFFF to soak it up. Does that reopen
Wow, great
that investigation
question.
or?
And I don't want to give the ministry any
question,
ideas if they're online. That's a great question, because when you got your RSC or whatever you were doing, it might not have been a concern, and it might be something that could be problematic in the future. I guess I'm going to take the easy way out, because I don't want to misstate, and every situation will be different, but that's definitely a situation where you're going to want to gather your environmental team together and have a conversation about what's going on, what you've found, how that might impact, if you have an RSC or otherwise. Certainly, you're going to need a team, and you're going to need to consider all of those particular elements. And maybe you're going to make a legal decision, or you're going to make a business decision on how to take the next steps. But I will say this, it's a possibility. It's something that may have to be addressed. And I don't know, Matter on, and maybe you're more willing to take a firmer position.
You said it.
I think it's risky though.
Yeah, and there's a timing element. Just for RSCs, for example, records of site condition in Ontario, there's always the possibility of a reopener if there's a new event after the RSC is filed, for example. This is just one obvious example. That can give rise to a reopener. In other words, the record of site condition only applies at the time that it's filed based on the data that is provided to the ministry, and that's what your record is about. But you have a spill the next day and it happens to be PFAS compound related, and that's a contaminant, and there's the new science RA process and all of that. It can reopen potentially your RSC and the limited protection from orders that you get from that record, potentially.
The conversation to have.
Yeah.
Yeah, no, that's awesome. Well, we're just here at the top of the hour. If you have to jump, jump. But I do want to address this one, considering we still have 200 plus people on the call, which is, and this one's personal, right? Which is, there's a number of reports related to promotion of so-called alternatives to PFAS compounds. Are these alternatives held to the same standard legal testing reporting as PFAS compounds? This is such a great question.
Yeah.
And I'll just jump in. The answer is yes and no, right? Because alternatives, they could still have PFAS. However, one of the colleagues within the industry, her big message is there's such a big burden on consumers today. You have to do your research. You can't plead ignorance. There's companies spending millions of dollars on their R&D to actually find alternatives. Patagonia is a really good example. Fjällräven's a really good example. The food industry has categorically changed. And we as consumers, we will have to undergo, right? Like we don't need our jackets in the rain to also really be oil resistant. Like we're not rolling around in oil, right? So, there's what do we actually need as society? And it will change. It'll be a little less amazing, but our environment will be way, way, way ahead as a society. So either of you can jump in on that topic, and just as we've got people sort of trailing off, just as closing thoughts on it.
Yeah, Josh, you're 100% right, and legally the answer is also yes and no, in the sense that you would come out, if the product was truly PFAS free, you would come out of some of these detailed legal obligations we've talked about today, reporting standards, guidelines, things like that. You still may be caught in the broader definitions of substance, contaminant, that are referenced across different areas of environmental law in different jurisdictions in Canada, as to what is that made out of, that substance, that packaging, how may it behave in the natural environment? Does it pose a potential risk? These kind of broader concepts would continue to apply, but you'd come out of the specific, PFAS triggered obligations. And then, yeah, Josh, you're absolutely right, which is, we've had amazing developments in science and technology, and it's led to amazing products. And we may be, as a society, needing to be prepared to take a quarter step back for the environment and the health piece to catch up, right? I mean, I think that's we're out of the true legal framework now, but if that's the more progressive view on how to take this forward.
So
I'll just add one other layer really quick, Josh and Andrew, and that is we've talked about the Environmental Law 101 framework, I think, today, and applying it to PFAS. Safe alternatives. Because Mark used the quote unquote safe alternatives, that triggered me to think about, is there some form of greenwashing that could be at play? So there's another layer to this that's competition bureau related in Canada, and it's federal, and that is this, when you promote a product in a certain way, and if that is false or misleading, that can trigger, and we have certain nuanced changes that make it arguably more stringent under the Competition Act now. The potential is there for a greenwashing claim, and so that's just another piece to the puzzle when you're dealing with PFAS or any products, any substances that may cause an adverse effect. But that's about how do you promote it. So his use of the word safe triggered my comment.
Yeah, no, well said. Okay, well, appreciate everyone's time. Appreciate you staying a few minutes after. Again, if you haven't registered, this will be recorded and available. And any feedback you have for us, and we'll have kind of contact email for William Shire available. So thanks everybody for your time. Thanks for joining us from coast to coast. Go Leafs, go. Bye, everyone.
Thank you,
Thanks,
guys. Great.
Thanks, everyone. Thanks very much.
Great.